The jury is weighing 3 arson charges against 30-year-old Jonathan Rinderknecht, a former Uber driver who now faces up to 45 years in prison if he's convicted on all charges. He's pleaded not guilty. The fire started on New Year's Day of last year, and embers smoldered underground for about a week before high winds blew them up and exploded it into the now Palisades Fire. And that fire burned more than 23,000 acres, killed 12 people, and destroyed nearly 7,000 homes and businesses. Prosecutors say Rinderknecht intentionally set that fire with a barbecue lighter out of anger toward the wealthy. The defense claims no direct evidence ties Rinderknecht to the crime, and they call the case purely circumstantial. So let's bring in our legal panel now. Brian Claypool is a criminal defense attorney. Neama Rahmani is a former federal prosecutor. Great to have you both. So this is unusual. Neama, how often do you have a case like this where the jury deliberates for a few days and then says, we can't do it?
It happens, but Elizabeth, what made this case unique is initially the jurors said they had a verdict and it was going to be read in the next half an hour.
So did they change their mind, or what happened?
I don't think they understand what a verdict means. It's got to be unanimous, 12 men and women agreeing. I don't think they're in agreement, because then they sent note after note saying that they're essentially deadlocked. So what will happen next is, I think we're headed towards a mistrial. The judge will read a jury instruction. Some states it's called a dynamite instruction, but it's essentially an Allen charge. And for folks that are familiar with it, in California, it's very light. In some states, it'll say there's a cost and expense and time of a new trial, and you should really reconsider your position. In California, though, it essentially says, well, talk to your fellow jurors, reconsider, but don't necessarily change your mind just to reach a unanimous verdict. So I would be surprised, given the notes that we've seen, if we're going to get a verdict. I fully expect there to be a mistrial, and really the only question will be, is it 1 or 2 holdout jurors? Do the DOJ retry this case? If it's closer to 50-50, I think they probably throw in the towel and walk away from this entirely.
Brian, it doesn't sound like it's 50-50 if they thought the jurors themselves sent out a note saying we have a verdict. Doesn't it sound to you like it might be 1 or 2 holdouts?
Yeah, Elizabeth, great point. If they thought they had a verdict, then it probably was 11-1, right? And then the one person was like, wait a minute, that's not what I voted. But look, at the end of the day, in this case, jurors are not robots, Elizabeth. I mean, people need to realize that. You could tell the jurors in this case, oh, you can't consider legal causation, right? We've talked a lot about that on your show, whether the Lackman fire actually caused the Palisades fire. Judge says, oh, you can't consider that. But these are human beings. These aren't Eskimos living in igloos. Anybody who lived in LA County during these fires, they heard and saw the news 24/7 for weeks about what led to the fires, what happened after the fires took place. And look, everybody was hearing that LA County Fire Department failed, that there was failed mayoral leadership, that there was a reservoir that wasn't filled, fire hydrants weren't working. These jurors know about all that, right? So you can't tell them, don't consider that.
Right.
They obviously have considered that, and that's why we're looking at potentially a hung jury.
Neama, here's the problem. The Lockman fire, which is the fire he's accused of setting, he lied. He said, I wasn't there. I didn't set it. Then his own cell phone tracking data showed that he was standing right next to where the fire started. He'd lied about where he was. Prosecutors put out all sorts of really disturbing stuff that he was saying online, pictures that he was drawing. He was a firebug. He had a fascination with fire. He wrote about setting people on fire. Here's the problem, though. Just because, even if you accept as a juror, he set the Lockman fire, it's another big leap to say he's responsible for all the death and destruction from the Palisades fire, because those embers that continued to burn underground until the high winds kicked them up and started the Palisades fire, the fire department didn't properly put that first fire out.
They didn't, and really that was the subject of our recent mayoral race here, and the reason Spencer Pratt, I think, did so well earlier this month. But if you're talking about causation, I'm going to talk about the law, and I'm going to talk about reality. It's what is reasonably foreseeable, and if you look at the law, it is reasonably foreseeable for firefighters not to put out a fire, for firefighters to even be negligent. That's what the law is. But in practice, I think you have an arson that was committed on one day and the effects that are felt one full week later or 6 days later. And that was always the biggest issue in the case. I think if you're talking about the Lockman fire, 8 to 10 acres, the DOJ doesn't prosecute this case. It's not a federal case. They're trying to hold him responsible for something else. And you have this case, you got the battle of the experts, I think, and Brian's right. If it's one juror, I think we're going to see a retrial. But if you can't establish that causation, then really the Department of Justice failed. And this is a huge win for Steve Haney and the defense.
Yeah, Brian, as we said, no eyewitnesses, not even any direct circumstantial evidence. But prosecutors did manage to paint a really disturbing picture of Rinderknecht, who did not take the stand in his own defense. You know, he hated anybody who was richer than he was, which, you know, he was driving an Uber. That's a lot of people. He idolized Luigi Mangione, who's about to go on trial for murdering a CEO of a healthcare insurance firm. There's sort of this, like, rage against the elite commonality between these two men.
Yeah, Elizabeth, that sounds like powerful circumstantial evidence, right? Really compelling, really dramatic evidence in the case. But look, at the end of the day, when you're accusing somebody of starting a fire on purpose, 7 people die, over 1,000 homes are gone. It's much like sexual abuse cases that I handle. When you're trying to go after somebody for sexual abuse, you got to have more than circumstantial evidence. Same thing with arson here. You've got to have some corroborating, firm, physical, forensic, eyewitness evidence. And Elizabeth, what a lot of people might not realize who are watching your show is there was another fire that happened too, the Altadena fire, which was a mile from my home, smoke through my house, had to have it, cleaned up. But look, in that fire, Elizabeth, there was video evidence of a transformer busting open and a fire igniting. Yeah, it was like a miracle that a 7-Eleven store caught that. So these jurors, I'll bet you anything, all those jurors in there are likely aware of that dramatic video evidence of what the Altadena fire, and they didn't have it here in the Palisades
Well,
fire.
we shall see what happens tomorrow. Very bizarre and strange turn of events to get this note from the jury. We have a verdict, and then another one saying, oops, we don't. We're hopelessly deadlocked. They're going to try again tomorrow. We shall see what happens and follow it closely. Brian Claypool, Neama Rahmani, thank you both so much. Really appreciate it.